You're watching The Legal Breakdown. Glenn, something just happened in Arizona that really caught my attention because it actually signals some pretty bad news for Donald Trump in his broader prosecutions. Can you explain what just happened?
Yeah, Brian, a legal development out in Arizona might really come back to bite Donald Trump in his criminal case in Washington, D.C. So Donald Trump's former chief of staff, Mark Meadows, we already know he's indicted down in Georgia. He's indicted in Arizona. He's an unindicted co-conspirator in Michigan. He is not yet indicted in Donald Trump's federal case in Washington, D.C., but stay tuned because I think there are more federal indictments to drop in D.C. So what Mark Meadows has been trying to do in his criminal cases is get them removed, that's the technical term, from state court into federal court because that actually opens up defenses for him. He tried to do it in the Georgia State RICO case, in which he is an indicted co-conspirator with Donald Trump, and he failed. The federal court judge ruled against him. He's appealing that, but at the moment he's still being prosecuted in Georgia State Court. Well, Mark Meadows just tried to do the same thing out in Arizona. He tried to move his case from Arizona State Court into federal court. Now, in the Arizona case, Donald Trump is an unindicted co-conspirator. He's not yet indicted along with Mark Meadows out in Arizona. But here is why this development is not only important because Mark Meadows lost again and is one step closer to being tried in state court in Arizona, but it may impact Donald Trump's ongoing case in Washington, D.C. So Mark Meadows went before a federal judge in Arizona trying to get his case moved into federal court, Judge John Tucci, and he said, Judge, everything I did on and around January 6th, everything I did together with Donald Trump, at the direction of Donald Trump, for the benefit of Donald Trump as his chief of staff, it was all official governmental conduct, all within the scope of my official duties as the chief of staff. And after a hearing on that issue, Judge Tucci said, no, it wasn't. Not only is it charged against you criminally, but none of it constituted your official duties as the chief of staff. Therefore, your case will not be moved from state court to federal court. Here's why that's so important, Brian, in kind of the larger scheme of things. This is a federal court judge who just ruled that all of that stuff Mark Meadows did together with Donald Trump to try to overturn the presidential election, not official governmental conduct, not within the scope of Mark Meadows' official duties. Now, let's shift over to D.C. We know that Judge Tanya Chutkan is just about to undertake litigation to try to figure out whether all of Donald Trump's conduct, whether his crimes, his conduct, his statements on and around January 6th constitute official governmental conduct, official presidential conduct, such that he might enjoy immunity against prosecution, or whether it's not official, private conduct, conduct of the candidate, and no immunity for you, Donald. That is what Judge Chutkan is about to litigate, and she now has a federal court judge in Arizona looking at, by and large, a similar body of conduct, of evidence, of crimes, lots of overlap between what Mark Meadows did at the direction of and for the benefit of Donald Trump and what Donald Trump did to try to retain the power of the presidency. And when you have one federal judge after an evidentiary hearing ruling that this kind of conduct is not official governmental conduct, therefore it doesn't warrant removal to federal court, and more importantly for Donald Trump's purposes, it does not warrant immunity against prosecution. That's not binding precedent on Judge Tanya Chutkan, but it is really important, I think, what we often refer to as atmospheric precedent, or persuasive authority is another term we use in the law. When another judge has decided a related issue or a similar issue, but that judge doesn't have authority over me because it's not an appellate court judge, we call it persuasive authority, or informally we call it atmospheric precedent. So it's actually a potentially really bad development for Donald Trump as Judge Chutkan moves toward litigating the issue of whether what Trump did was official or unofficial conduct.
Well, let's look at this from the flip side. Let's say, for example, that a judge did rule that Mark Meadows was protected because this was an official act, and so it did fall under the umbrella of presidential immunity. Would the Trump team then point to that ruling as evidence to help them in Trump's effort to shield himself?
In a New York minute,
Well,
Brian,
there you go. I feel like that answers the question, right?
They would package that ruling up and instantly file it with Judge Chutkan saying, you see, Judge, we've been saying all along, everything that Donald Trump did, including what he did together with Mark Meadows, official governmental conduct, so he cannot be prosecuted for it. You bet that they would have taken advantage of a contrary ruling from Judge Tucci out in Arizona.
So then does this offer the same degree of heft when we're looking at this? In the same way that Donald Trump would have used this as foolproof, airtight evidence that he's in the right and that he is protected by presidential immunity, could the prosecutors then take this and say, look, I understand that this is not binding precedent because that needs to happen at the circuit court level or the Supreme Court level, but in terms of the strength of this atmospheric precedent, is this going to factor in as great as it would have if Trump won and he tried to use it for himself?
Yeah, good for the evidentiary goose is good for the evidentiary gander. So I think what you're going to see is Jack Smith, who has a motion or a pleading due to be filed with Judge Chutkan on September 26th, laying out all of Donald Trump's crimes, conduct, and statements, and making his best arguments as to why they're all unofficial, right? So they should not enjoy immunity against prosecution. You can bet in that pleading Jack Smith files, he'll probably make mention of the ruling by Judge Tucci out in Arizona and saying, Judge, we understand. It doesn't bind you, but it's persuasive authority if what Mark Meadows did together with Donald Trump, which is also included in some of the prosecution in Washington, D.C., some of the evidence that is included in the indictment against Donald Trump, some of what he did together with Mark Meadows, if it was not deemed official conduct in federal court in Arizona when another federal judge, wrestled with that issue, you should, come down on the same side of that issue and find and rule that, Donald Trump was not engaged in official conduct where that conduct overlaps with what Mark Meadows did, which was ruled unofficial conduct.
All right, let's finish off with this. Does Mark Meadows dare appeal this? And I ask this because if he appeals it to the circuit court and the circuit court agrees with the trial court, then you do have precedent. And then Jack Smith can say, look, we have actual precedent, not just a ruling by a trial court judge, which could be scattershot. I mean, we've seen Judge Cannon make her crazy rulings that don't actually hold any weight with regard to the constitutionality of special counsels. And the same could be true of this trial court judge in Arizona. But if Mark Meadows decides to appeal it to a circuit court, and they uphold the trial court decision, then Jack Smith has actual precedent to look to, and this might be more influential in terms of other judges agreeing with that circuit court. So does he dare appeal this loss, knowing how it could negatively impact Donald Trump?
First of all, Brian, you've obviously earned your law degree at this point, because, it's a great point. Trial court judges don't really make law. They don't set precedent. Appellate court judges do. So first of all, to directly answer your question, of course, Mark Meadows appeals it. He doesn't really care about the implications. He will appeal this ruling, just like he appealed a similar ruling in his Georgia case where he's being prosecuted. Here is kind of the trick to when an appellate court decision is precedent and is not precedent. A federal circuit court of appeals, when it decides an issue, it creates precedent, but it only creates binding precedent in the federal circuit in which it sits. So Judge Chutkan would look to an appellate court opinion out in Arizona by the Circuit Court of Appeals and say, okay, that's certainly precedent in that federal district, and I find it very persuasive, but technically speaking, I'm not bound by it, but it does up the ante, the power, the persuasiveness when appellate courts begin deciding these issues, as opposed to just trial court judges around the country deciding these issues.
Okay, well, that answers that question quite well then. Well, look, we will stay on top of this issue, especially as Mark Meadows inevitably appeals it, and what kind of atmospheric precedent, at the very least, this will set for Donald Trump as he tries to protect himself based on this same issue. So for those who are watching right now, if you want to follow along with not just this case, but the rest of the prosecutions that Trump is contending with right now, please make sure to subscribe. That is the best way to support what we do. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.